Welcome to another legal talk here on eRadio with Hahn Hahn attorneys, and today we've got another type of scenario. You come up with an amazing new concept for a retail business. The business model is a network marketing pyramid wherein different layers of the pyramid pay a different price for products. The products are specifically designed to be identifiable as your network's products, and some have secret recipes. So how do you now protect your idea when you look for investors? That's the big question. And joining us from Hahn Hahn is Janusz Luterek. Janusz, welcome back to Legal Talk.
Good to be chatting to you again about this interesting topic.
Yeah, no, thank you so much for proposing this topic, Janusz. And I want to ask you, how would you now protect your idea when you're looking for investors? Because obviously you have to tell them about it.
Yeah, this is a real chicken or the egg situation. And all innovators, especially small private individuals or small companies, face this problem because they don't have the money to begin with to start spending a lot of money on protecting their idea. That's why they're looking for investors. But if they tell the investors their idea, your chances are better than even that they'll tell you, no, they're not interested, and the next thing they're using your idea. So it becomes a juggling act. And so the first way to do it is you need to have a proper, solid, what's called a non-disclosure agreement, an NDA. When you go to see the investor or when you speak to an investor, you first get them to sign a document that says they understand that you're disclosing confidential information to them. They're not going to use it for any purpose other than negotiating with you. And if they're not interested, they have to walk away. They cannot use your idea for any purpose. But what's very important about the NDA is it has to have attached to it some sort of description of what the idea is, because what I see a lot happening is people sign an NDA they download off the internet. They want to save money. They go to ChatGPT, they get this document. But what happens later? The document says, I promise not to use anything you tell me in the meeting. But the people have different versions of what was said in the meeting. You need to have a properly written down or recorded version of our disclosing to the investor when you get them to sign the NDA.
Okay, yeah, no, that sounds interesting, but that's where you come in and you can help us. But what protection is available for specifically or the specially designed products such as a new packaging shape or type? What kind of protection are we looking at there?
Yeah. So a lot of people think of patents. People call me, they say, I want to patent my new design. And in fact, it's not a patent. If you want to register something like a shape of packaging or a new configuration of packaging, there's a cheaper type of protection called a registered design. Afrikaans has a very interesting term for it. They call it a model. People think the translation of design is ontwerp, but it's not. In this context, it's model. And there's a law called the Modellenwet. What happens is you register literally the drawings or the photographs of your prototype, and then you have protection for if anybody makes a product that looks like yours or is very similar. It doesn't give you a huge amount of protection beyond that, but it's simple to obtain and it's much cheaper than a patent.
Okay, and can you prevent the manufacturer from simply using your secret recipes and launching their own products under their brands? Can you actually prevent it?
So here we are at a stage further down the line. So what's happened is you got the investors involved. You've now started developing your business. You've gone to third-party contract manufacturers, and they need to make the products for you because you can't make all the different products yourself. And now you've got to tell them how to make it. So you've got to give them the recipes. So first of all, you want them to sign NDAs, just like the investors did. But secondly, at this stage, you may already have cash flow and you may want to patent your recipe because that will give you much better protection than a non-disclosure agreement. Because whereas a non-disclosure agreement is only between you and the person who signed it, when you filed for a patent, your protection is against the world. If somebody walked into the factory, saw your recipe, walked out and went and did it. Very difficult to stop them with the NDA because you don't know those people exist. If you find out about them later and you've got a patent, you can stop them without having to prove that they had been to your factory.
Okay, and can you patent your whole idea or perhaps the name of your network?
So this is an interesting question. People phone you and they say, I want to patent my company name. It's actually called a trademark. So when you want to protect the name of your network or the name of your business, you're actually going to register a trademark. The problem that we have is that in South African law, and actually most countries in the world, you can't patent a business idea. So you can't patent your business model. Unfortunately, it's not protectable. Patents are really there for methods of making something or the item that you made, a new process, not a business method. But what you can do is register your trademark, and then together with all the other protection you've got, it protects your business as a whole.
And then finally, how do the big network marketing companies protect their systems and ideas, Janusz?
So first of all, they rely obviously on contracts with all of their distributors. So if you're a distributor of one of these big marketing companies, you have to sign a contract with them. You can't compete with them. You can't try to reverse engineer their ideas. They obviously register their trademarks. So if you buy from one of these companies, their logo, you know it's from them because nobody else can use the same logo or a similar logo. When they have new product designs or a new cosmetic cream composition that's got new ingredients in it, they will register a patent for that. So they use a whole basket of different intellectual property types. It's what we call intellectual property to protect the idea, the system. And then, of course, if they become a franchise, they will also have a franchise agreement which covers a lot of the methodology of how the business has to be conducted, and it contractually binds the people to do that. So it gets quite complicated. It all starts very simply, making sure your idea doesn't get stolen when you're trying to get investors by getting them to sign NDAs, or, of course, if you have the money to begin with, file your patents and trademarks early.
Janusz, Luterek, thank you so much. Very, very interesting. Janusz is, of course, from the Food, Consumer and Technology Law Department at Hahn Hahn Attorneys. We appreciate your time. Thank you so much.
It's a great pleasure. Have a good afternoon.
Are you or your business in trouble and struggling to find a solution? Call Hahn Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn Hahn Attorneys, Wednesday mornings at 10 on eRadio.